It's always a guy. It's like, man, she saved my life. She made me such a better man. I'm so much less of like a, since she came into my life. But very rarely do you hear the other flip side. Like,
but yet you don't see it on screen
never see
often.
it.
But I
It's
think
always-
that's why like men and women see this movie. They're not just like.
Directing is a very complicated job. You have to hold the entire vision of the movie in your head and then find ways to communicate it and get everybody on the same page. And then acting is its own animal. Acting, especially with a role like Ryle, with complex, deeply painful, disturbed man, it's very hard. And there were many times, throughout the course of the movie where it was challenging. And as a director, it's my job to navigate all the personalities and to figure out how to get us all in the same direction. And yet those challenges are also beautiful. And we work together to create this beautiful piece of art, and I'm proud of it. And I believe that the cast is proud of it, and Colleen's proud of it, and I hope at the end of the day that the fans will be proud of it.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. If you are Blake Lively today, you are not feeling good about this case because Blake Lively is going to be up against a very strong motion to dismiss that has just been completely pled by Jed Wallace. And his arguments to have his case dismissed are strong. I don't know that she's going to win this one. And his lawyer Charles Babcock did some of the most brilliant arguing and lawyering and writing I have seen to date, and it's also quite humorous. And Blake Lively's case could literally come to a collapse if Jed Wallace is dismissed from the case. And I'll tell you why. Because Jed Wallace is at the center of her alleged conspiracy theory. She believes that it was Jed that orchestrated this campaign of social combat that went all over the internet and basically talked about her and spread mistruths and said negative things about her. And it's her belief, even though it might be wrong, that Jed Wallace was the person that started and changed everything that happened on social media. And then Jed Wallace signed a sworn declaration, and he told the court he did none of those things. He described what he did for Wayfair, the job that he did, who he interacted with, and the directions he gave to them, which was to do nothing because Blake Lively was receiving organic backlash and they really didn't need to do anything because the internet was against her. They were mostly supportive of Justin, and it didn't seem like it would be needed to even try to influence anyone. And nor would it be needed to try to go out there and defend Justin because the internet was already fed up. They had made their position known. The backlash she was receiving was organic, and it was from Colleen's fans and people that watched the film. And Justin didn't have to do anything. Kind of like how Justin doesn't have to do anything right now, and she keeps looking bad. But Blake is trying to get this case to stay, and she's using arguments because she's trying to claim that New York has jurisdiction over Jed, but really it doesn't. Jed's in Texas, and in federal court, if he's not from New York and he didn't direct any of the work that he did towards New York directly, and if he is not a New York company and he's a resident in the state of Texas, he has a very likely chance this case will get tossed on jurisdiction alone. And I'll tell you why. I was sued in federal court in Washington. I am not a Washington resident. All the work I did was not aimed at Washington. I worked in Minnesota the entire time, and I won because they brought the case in the wrong venue. Now, getting it tossed on a jurisdictional issue doesn't mean she can't refile it, but it makes the case against Wayfair fall apart. And if he's not a part of the case itself, her case becomes very, very, very weak. So he's also trying to say that she failed to state a claim. And if I'm being honest, I think they might have actually met the burden to have this tossed on failure to state a claim too. Again, I'm not a lawyer. I did reach out, though, to the Tilted lawyer this afternoon, Omar, and asked him what his thoughts were. He said he's going to stream on it later today, but he did think that Jed's motion might get tossed, or Jed's case might get tossed. Jed doesn't believe that the state of New York in federal district court, which is in New York, has jurisdiction over him because he says that he's a Texas resident. His place of business is in Texas, and he didn't do any work on this case that targeted the state of New York. He also comes back at her about his own declaration as as a solid argument that he's refuting the claims against her, and in her complaint, she actually provided no direct evidence of his involvement because she has no communication that puts him in place, and she can't even state what he actually did. So here's just a little bit of what they wrote. Lively claims wrongly under settled and binding authority that this court should ignore the Wallace Declaration. But even if the court does not credit the Wallace affidavit, it must, though. Plaintiff bears the burden of establishing conspiracy jurisdiction, yet does not allege when or where the conspiracy was formed, who was in it at what point in time, what the alleged co-conspirators, none of whom are New York residents, performed in New York, with one irrelevant exception discussed below, and how the conspiracy was aimed at or directed at New York, especially when the complaint does not allege any territorial boundaries for the sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone, not just New Yorkers, that challenged his Baldoni's brand. Another one was when the Wallace parties joined the alleged conspiracy, apparently it was later, and what they specially did to further the aims of the conspiracy in New York, and Wallace's awareness of those acts taken by the alleged co-conspirators, and that those acts were in New York. It is an odd choice that she picked New York because filming did not happen in New York. The contract she has is in and is supposed to be litigated through the state of California. Baldoni is not a resident of New York. None of the Wayfair employees or the Wayfair parties that she's suing are in New York. And generally, for defendants to have a court to have jurisdiction over them, the plaintiff has to go to the forum that the defendant resides in. And then that plaintiff is basically agreeing that they have jurisdiction by going to the foreign court. But if she's bringing foreign state defendants into her state, she has to tell the court why they have jurisdiction over them. And Jed's saying that she doesn't have that. It says if the court reaches the merits, it should dismiss for the intentional infliction of emotional distress. To avoid Hustler, Lively argues that Wallace and Street did far more than publish statements, but her complaint says otherwise, and her own California cases support dismissal. For false light, either New York law or Texas law apply because Wallace's alleged conduct occurred in Texas, and the purported ultimate impact was felt by Lively in New York. And as for FEHA, Lively cites to the amended complaint do not add up to knowledge, meaning that why would he know that? He's not in California. And her California cases go against her, and she ignores that Wallace was not her employer. Another issue they say is that in advocating for personal jurisdiction, Lively never identifies any specific co-conspirator committing any specific act that qualifies under Statute 302A2, an act that taken while physically present in New York, and that she's seeking to impute to Wallace through the conspiracy theory jurisdiction. In fact, she never once cites New York's long arm statute, just like conspiracy theory jurisdiction is not substitute for purposeful availment. So she has a problem because in order for him to come in as a foreign defendant, she has to prove that something happened in New York and that specifically something Jed did targeted New York. And he's saying she doesn't even argue that anything he did targeted New York in any capacity. No contacts in New York. And this is how little of he's involved in this entire complaint. For Wallace's participation in the conspiracy, Lively cites 2 paragraphs to support that Tag engaged Mr. Wallace and Street Relations to design and implement a social combat plan. The first paragraph are text messages between Abel and Nathan that never mention Wallace or Street. The next paragraph is an allegation on information and belief that Tag engaged Mr. Wallace around the same time in early August 2024 to design and implement their social combat plan. First, this is exactly the type of conclusory allegation based on information beliefs that are not sufficient to provide. So he's basically telling the court that she's somehow made the decision that Nathan described that they could use social combat, right? And they're claiming that even though Nathan never said that that's what Jed was going to do, she's inferring that he was brought on to do that, even though it was never said that he did that ever. So it's speculative. It's not actually an allegation and it's an assumption. And to bring complaints through, it has to be more than assumptions. You'd have to have actually evidence that he did this. And there's really nothing in the complaint that states that he did or that she knows that he did. They also argue that Lively wants them to throw out the declaration because it answers the questions that she doesn't have in her complaint against him. So she says that he did these things, and then he has a sworn affidavit, which is better than anything she's given or provided to this court. She has never signed a sworn affidavit under the penalty of perjury. He did. And he told the court that he did not post anything on social media on behalf of the Wayfair parties or about Lively, Reynolds, It Ends With Us, or any of Lively's or Reynolds' businesses. They did not direct or ask anyone to post anything about the same. He did not publish directly or indirectly on information or content, negative or otherwise, regarding Lively. And he specifically forewears that a social combat or social manipulation plan is not a service he provided related to anything in this case. Setting aside his declaration, all she has is an allegation that Tag hired him to design and implement, not that he actually did design or implement anything. And that paragraphs 215 and 260 do not plausibly allege what overt act Wallace actually ended up taking, namely that Wallace designed or did to implement any so-called plan. Lively wants this court to draw an inference from her conclusory information and belief that Wallace was hired to do an retaliatory campaign and that he then carried it out. But she never gets into specifics. Even if credited by that trier, this allegation would not suffice to establish jurisdiction over the defendant. And it's true. A lot of people that are following this case don't understand what she even thinks was the smear campaign. Talking about posting and defending Justin isn't actually smearing Blake. Posting a comment about Blake that isn't positive isn't actually smearing her. A smear campaign would be to intentionally put out content that's false and defamatory, but that's not what they did. And then they finally get to the meat of what they claim Lively said Wallace does. Seeding, manipulating, and advancing disparaging content on social media platforms and internet chat forums. But this is just another way of saying Wallace and Street retaliated against her, a threadbare recital of her claim, and a legal conclusion couched as a factual allegation. These are more vague references to a digital team, not Wallace or Street, except that Lively says Nathan and Abel merely discussed working with Wallace. She also bolds and italicizes other verages like efforts to shift the narrative from some random tag employee who's not alleged to be a part of the conspiracy. But bolding and italicizing her claims do not make them any more specific in the face of Wallace's declaration explaining specifically that he did not post, like, boost, or ask anyone else to do so. Whatever she says about the tag, Nathan or Abel, what she does not say is that Wallace made any particular post, like, or otherwise boosted any story or post, or really explained how Wallace joined in the alleged conspiracy to destroy her. That's because if it happened, which Wallace cannot deny it because he was not there, but again, he doubts, it did not involve Wallace. As he explained in detail, his recommendation was to do nothing on social media because Baldoni was already organically crushing it on Reddit. This paragraph, however, admittedly corroborates one allegation in Lively's amended complaint, where Lively posts a chart showing online sentiment began to turn negative in July, 2 weeks before Lively alleges Wallace was hired. Huh, isn't that interesting? So you mean the public was already turning on her in July before she says a smear campaign was implemented? That's weird. Argues that she stays at a high level because she lacks specifics, but now she has them in the declaration and she wants the court to disregard them. And they won't. They can't. They said based on the fact that she doesn't have any actual claims against him and has no proof, that they have to dismiss. Jed's argument is similar to what Ryan Reynolds is trying to do, saying, like, you don't have the evidence. You didn't say when, where, why, blah, blah, blah. Except Baldoni actually does have the evidence. When it comes to Jed Wallace, she has nothing. She doesn't know what he did. She can't go into Reddit and describe one single post he boosted. She can't look at a single comment he made. She has no way of tying him to anything. She doesn't have any text messages, emails, communication, or anything where Jed is talking about what he's done. She has no digital footprint of anything that he's done. And in order for her to bring the claim in court, he's saying she hasn't met the burden that the claim even has enough evidence to move forward. And so it should be denied based on that and that alone. It says without a prima facie showing, meaning she has the evidence, she's not entitled to jurisdictional discovery. Plaintiff offers no reason to question Mr. Wallace's sworn statements or to believe that its requested discovery will yield a basis for the court's jurisdiction other to call it self-serving. One of the things that she keeps using, and she's using even in Texas, is that she's trying to claim that she filed the first lawsuit and she gets the first filed rule, meaning that whoever filed first gets jurisdiction. But he says that that doesn't work because he wasn't named in the lawsuit that she filed before she filed it, before he filed his against her. And Wallace and Street were not involved in this lawsuit until she named them 2 weeks after Wallace's suit in Texas federal court. And the first filed rule only applies when the first filed court actually has jurisdiction over the parties and the claims. And they're saying this court lacks jurisdiction over Wallace and Street. So they believe their argument is that the court has no jurisdiction over him. The first filed rule is nonsense and meritless because they have to have jurisdiction over him to follow that rule. And then she cites the Wallace's Texas actions includes anticipatory declaratory judgment relief and argues that it's not entitled to priority under the first filed rule. And they argue that a party has a right to seek declaratory judgment where a reasonable apprehension exists that if it continues an activity, it will be sued by another party. But he's saying that he did not only bring an anticipatory declaratory judgment, he brought a substantive claim for relief for defamation as well. And then for his failure to state a claim for the intentional infliction of emotional distress, they're saying that extends beyond a gravamen of falsehoods. She cites paragraphs alleging that Wallace and Street published negative comments or elicited others to publish negative comments. Wallace denies making any such comments, but taking Lively's allegations as true, the gravamen remains Wallace's First Amendment activity of speech, even if, as alleged, that speech was not under Wallace's name. So posting a negative comment about someone online is actually not an actionable claim. I mean, you can post something that's not positive about someone. You have a First Amendment right to share your thoughts and feelings about people, right? And that's what he's saying. And then they say that actual malice allegations then amount to one paragraph that she has a threadbare recital of the element of actual malice and the conduct of and knowledge of people other than Wallace and Street. There are no factual allegations that knowledge or reckless disregard for any supposed falsities were brought home to Wallace and Street. Rather, she points that to what Wallace's so-called co-conspirators were allegedly spreading information that they knew to be false. Nor are there any factual allegations what Wallace or Street actually did to work to bury or destroy Lively. Rather, the response just cites paragraphs in the amended complaint that refer to the Wayfair team without any factual support identifying which, if any of these posts that Wallace or Street supposedly seeded, she does not allege any specific negative post about her business accounts, or her loved ones came from Wallace or Street. And then they use her own words against her because in Texas court, she went to court and she told the court that all of his work was done in Texas. And she told a court in order to do a deposition and seeking a deposition in Hays County that most of his work was done in Hays County. Thus, why would she go to New York to bring the claim against him if she told a Texas court that it happened in Texas? The biggest problem with her, honestly, and what he points out, and I won't read it directly, is that she makes these claims that like the social media combat was happening. She pulls out these comments that she claims are like ones that she believes he put, but she has no proof that he made these comments. She has no proof that any of these accounts are attached to her. she's just pulling comments that aren't nice and saying they're all him with no reason why she believes they're from him, which I think is going to be really hard for her to overcome. Listen, it is hard to prove just about anything that happens on the internet, and that's can be good or bad. And then in this case, she has no proof, only an assumption, which won't help and isn't going to be a very strong case in court. I don't think a jury is going to be very compelled by what she's bringing forward. She also claims that he aided and abetted against her with the FEHA claims, which are the new California laws. He says here Lively's claims turn on retaliating against her for sexual harassment and HR complaints, but she never alleges that Wallace knew of any HR complaints or claims for sexual harassment that qualify as protected acts under FEHA. She merely mishmashes one allegation about Wallace with one about an HR complaint with Nathan and Abel without explaining how Wallace knew or claiming he did. And then in a reference to misconduct, it's not even misconduct alleged by Lively, so it can't be the basis of her retaliation claim. She fails to connect allegations to Wallace in any way. He says Lively has not even alleged Wallace's knowledge of any particular act or protective action for retaliation adequately. But even if she had, it would not be enough. As Elk says, the alleged aider and abettor must have known the employer's conduct violated FEHA. He didn't know anything, right? Their conclusion is the best, though. Beyond being listed as parties, the Wallace parties are barely mentioned in Lively's 141-page, 482-paragraph, 5 attached exhibits amended complaint. If this were a Hollywood movie, the critics would deem the script overwritten and the peripheral characters, Wallace and Street, underdeveloped and therefore cut from the film. Of course, no one likes to be described as a bit player or an afterthought, but the Wallace parties will get over it because this lack of attention necessarily leads to the conclusion that there is no adequate factual predicate for this court's exercise of jurisdiction or venue and the case. As to them, should be dismissed without prejudice. In the alternative, the claims against them should be severed and transferred to the United District Court for the Western District of Texas Austin Division, where a claim against Lively by Wallace is pending. But if we were truly into an almost happy ending, the court would reach the merits, and if it does, dismiss the claims against the Wallace parties with prejudice. We predict the Wallace parties and critics would like that. A cleaner storyline, and sadly for some, less attorney's fees. So, long story short, that's hilarious. And it's exactly right. He's barely mentioned. She has nothing to tie him to it. She has no communication with him. And like I said earlier this week, everything is pled on information and belief. And she even told a court in Texas that she doesn't have the evidence needed to plead a case against him because she was going to do a deposition to see if he was involved in it, to find out more about who he was and what he was doing. She told a court that that's why she needed to do a deposition in the possibility to avoid frivolous lawsuits. She needed more facts. She didn't have enough facts. Instead of doing the deposition and instead of getting the facts, she instead added him to the lawsuit when only a couple weeks before told a court in Texas she didn't have the facts necessary to bring a claim against him. And now is trying to tie him into some conspiracy to make it more robust that this quote unquote smear campaign happened. And yet, Wallace's attorneys are right. She does not state at any place what actual defamation occurred, what was actually said that was destroyed her, and how any of this was coordinated in retaliation for her speaking out against sexual harassment. The smear campaign doesn't make sense. And this could actually get him dismissed. And if he's dismissed, it weakens her entire case against Wayfair because she's saying that Wallace is the key to the smear campaign. But if he's the key and she can't actually prove he did anything and he says he didn't, she can't win. So what if Friedman strategically had Wallace do this to see what the judge decides? And what if he does dismiss Wallace? What then was Lively to do? Her case becomes a hell of a lot weaker. And his attorneys did an excellent job really exposing the fact that her claims against them are weak, which is why Friedman said he didn't even do a motion to dismiss because he wants to work with the complaint that she's already provided. He doesn't want to give her a chance to amend. Well, this could possibly give her a chance to amend, right? If she wanted to. If they dismiss without a opportunity to amend her complaints, but she didn't ask for leave to amend. Long story short, I think Wallace is going to get tossed, and I think Blake is screwed. But that's just my opinion. What are your thoughts? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.